Defensive privilege. This is me. Blank screen again. Well, this is working out. I hate torts. I literally hate torts. Literally hate every section. Right now, I hate my computer. This is a joke. I'm just waiting for this computer to download its ebook. Doesn't seem to want to happen for me. So, all over again, because the same. My computer. First moment in time when I'm live. Outline. This kind of the issue questions, strictly general consideration, defamation, and privacy. Big sections. Adult starts line with the outline. There was of emotional distortion, trespass, is placing tension, conduct, is other. Stress with outrage causes emotional distress. Intentional with of another of that, which the use and okay. Dispossession, forced sale. Distress is what I tip to abounded about the conduct. Substantial and just public or personal torts. Consent, capacity to consume and use it. Consent give others defense of property on these from the belief that defense of others committed on a third party. If the tort is being shopkeeper's privilege for a reasonable time. If yes, in any of these circumstances, the defendant use reasonable force. Necessity is another defense, but only to property torts. A public necessity is absolute defense if for public good. A private necessity, the defendant is privileged but pays actual damages. Miscellaneous. Intentional torts is the wrongful institution of legal proceedings and abuse of process. And business torts. Interference with contractual relationships, interference with prospective advantage. Negligence, we'll go into next. Before doing that, I'm just trying to scroll a bit over. Okay, maybe I won't. Just keep someone that take me to somewhere else. Okay. We're just going to go into negligence. Duty of care not to subject others to unreasonable risks of harm. So A, act or omission. B, foreseeable plaintiffs. And C, what duty? Common law standard of care is a reasonably prudent person, professional, child, common carrier, and innkeeper. A taxi driver is a common carrier. Owner-occupier of land. Affirmative duties to act. And statutory plaintiff within protected class. And was the injury the type to be prevented? That's when there's a statutory duty. Breach of the duty is also a required element. It's a factual discussion as to whether the defendant met adopted standard of care. By customer usage or balancing risks against burdens. Violation of statute, legal effect of violating the statute. Right, ipso loquitur, negligence in the air. Negligence is attributable to the defendant, and the legal effect. Causation, actual or factual cause, but for substantial factor is within that actual or factual case. Within the proximate or legal causes, the question was the consequence foreseeable, was the intervening act or event foreseeable. And then damages is the last element required under the negligence formula. The types here are general, eggshell plaintiff. I know there's more at the bottom of this page. Defenses to negligence is contributory negligence, which is a complete bar. Assumption of risk, which is voluntarily assuming a known risk. And comparative negligence can be pure or modified, which doesn't eliminate liability, but can reduce it to the percentage of fault. Strict liability is the next section. There's really only two parts in this section, which is strict liability for dangerous and trespassing animals, as well as strict liability for abnormally dangerous activities. Activity involves serious risk of harm. Activity cannot be performed without risk of serious harm, regardless of due care, and activity is not common in a particular community. So moving to the next page is products liability. There's 4 theories. There's strict products liability, negligence liability, implied warranties, express warranty, and misrepresentation. For strict products liability, for defective products, well, defective products is the only, I think, one kind of a cause of action that can be brought for strict products liability, but there's 3 types. So manufacturing defect, design defect, and the information defect, which would involve inadequate warnings. Under design default, though, there's the product was not safe for its intended use, and the product could have been made safe without serious expenditure or a serious impact on its price or utility. There's 2 formulas, consumer expectation and balancing, for strict products liability. Then there's causation is a required element. There's actual approximate types. And then for damages, same as negligence, the courts will deny recovery if only economic loss is involved. Negligence, same as any negligence action when it's brought for product liability. And that includes the duty, the breach, the causation, and the damages. Regular elements, but for duty, standard of care and foreseeable plaintiff are spelled out. Breach, apply the standard of care applicable to this defendant. Note, unlike strict products liability, defendant's fault must be established. And then in causation, probably actual and proximate, still the only ones. Damages is the only thing written there for the damages element. Next, implied warranty, which names 2: implied warranty of merchantability for fitness or ordinary purpose. Implied warranty of fitness for a particular purpose is the second type. Express warranty and misrepresentation is just hanging out there in letter subpart E without any additional breakdown. But we know what express warranties are as opposed to implied warranties. That would be the example of this tennis racket will last for, or is made of the strongest composite of titanium, and it's actually made out of plastic. That's a warranty that the salesperson gave to the buyer, and then when the buyer learned it was false, came back claiming that express warranty was violated, in fact, by misrepresenting the fiber, making up the bracket. Anyway, general considerations: are there 2 or more defendants? Vicarious liability, employer-employee relationship under respondeat superior, and then 2, tort committed within the scope of employment. B, independent contractor, generally principal, not liable, except, go on to the next page. Except inherently dangerous activity or non-delegable duty? One of the things I learned was a non-delegable duty, which is it's like the duty to invitees, like if the landlord's property is being used for commercial business, whereas if it was licensees who are invited by the tenant apparently is liable for harm. This is from an MBE question. I don't know. I just misinterpreted that. Anyway, partner or joint venturer, driver of automobile, Bailey's, children, and patron of tavern are all other types of respondeat superior. Vicarious liability, fact patterns or issues. And then there's joint and several liability, releases, contribution, and indemnification. Did someone die? If so, think about survival and wrongful death acts. C is defendant a family member, government, or charity. If so, think about tort immunities. All right, last part is defamation and privacy. For defamation, requires a defamatory statement of or concerning the plaintiff and the publication of the statement. Damages involve injury to reputation. These can be presumed if libel or slander per se. Okay, when can they not be presumed? Anyway, I feel like they meant to say libel per se and slander per se, but they just said libel and slander per se, and I don't see anything about libel per se. We're just plain old slander. So I think this is a little bit deficient, but we do have a definition for slander per se, whether the defamation entails or harms the plaintiff because it is a statement about a loathsome disease allegedly the plaintiff has. What else? Sexual misconduct or moral turpitude, like for instance that the plaintiff commit a crime, and then business profession. So I think that's lump they're not giving it to me in that order, but lump is the mnemonic. Loathsome disease. U stands for the sexual promiscuity. I just forget how it comes up. And then moral turpitude or crime, and profession. Like saying that someone's bad at their profession or cheap, people out of things like that affect the reputation. Took a little time to describe. For slander per se. Otherwise, unchaste is the year. Okay. Unchaste, falsity and fault have to be proven. I don't think they have to be proven when the damages are assumed. But where they're not assumed, I do believe that they have to be proven, or maybe proven in a different way. So it doesn't give me any definition of falsity or fault, but under fault, actually, the status of the plaintiff, public official or figure, private individual. In standards of fault is constitutional malice from New York Times versus Sullivan, and negligence from Gertz versus Welch, which is state law, in parentheses. Invasion of privacy is the appropriation by defendant of plaintiff's name or picture for defendant's commercial advantage. Intrusion into plaintiff's privacy or seclusion. Publication of facts placing plaintiff in a false light. And publication of private facts about the plaintiff. I think there's a mnemonic for this. Excuse me. But I can't remember what it is. Defenses to defamation or invasion of privacy. They include consent, truth, when the plaintiff is not obligated to prove falsity. Absolute or qualified privilege is another defense. Products liability. Sample template. Checklist, attack plan, strict liability, negligence, or warranties, express, implied, and misrepresentation and intent. So organizational tips: if strict product liability and negligent product liability are both issues, raise SPL first because it is easy to prove since it does not require a showing of negligence and is the most common basis for liability. Then raise NPL, mini IRAC, the issue, and you can refer to the above analysis for elements that have the same analysis as SPL, strict product liability, which should be actual and proximate cause and damages. Strict product liability. Here's how you would begin your essay. With that heading, and a commercial seller who places a product in the stream of commerce may be strictly liable in tort for injuries caused by a defective product. In order to prevail at SPL cause of action, plaintiff must show the defendant is a commercial supplier of a product, production or sale of the product that was defective when it left the defendant's control, actual and proximate causation, and damages. Commercial supplier. I took some notes on torts before. Yeah. Those mnemonics are here. Yeah. Something like that. So CLIP stands for commercial appropriation, false light, intrusions into seclusion or solitude, and public disclosure of private facts. So that's CLIP. For the privacy torts. What else do I have here? Do I have one for defamation? Element doesn't seem like it. No, I think that's the only gift I get. Sorry, I took a detour there because strict product liability is like a little bit harder to prove than I thought. Again, you need a commercial seller, which I don't know why they decided to use different words. Like, I want to call it a participant because it could be like your wholesaler, could be your distributor, could be your could you be your manufacturer? So whoever put it in the stream of commerce. And then it was defective when it left their control. And that's not all. The rest are kind of normal. That's causation. Causation damages. Actual causation damages. Did they say approximate? Yeah, actual approximate causation and damages. So it's actually not that bad. All right, negligence. Oh wait, commercial suppliers defined here too. A commercial seller may be liable for supplying unsafe products here, and then you enter the facts that establishes the defendant is a commercial seller who placed the goods in the stream of commerce. Noting a casual seller will not be held strictly liable. Also, strict product liability only applies to products and not services. Whether or not contractual privity exists between the plaintiff and the defendant will not prevent the plaintiff from recovering. Because any foreseeable plaintiff, including a bystander, can sue any commercial supplier in the chain of distribution, regardless of a contractual relationship between them. So, um, so privity. So it's not applicable to a casual seller and privity is not required.